Good day, good afternoon, good evening, ladies and gentlemen, dear members of parliament, dear participants. My name is Roger Wiesinga. I'm the manager of the Human Rights Program at the IPU. It's a great pleasure for me to moderate this discussion this afternoon, for us at least. This is part of a series of webinar series, and it's the second one that we're holding. It's part of a series which is called From Theory to Action, Parliamentarians Against Hatred Based on Religion or Belief, Crafting Pathways to More Peaceful, Inclusive and Just Societies. The first of this series of webinars took place at the end of last year, and it focused primarily on freedom of religion or belief. This time, we will focus a bit more on freedom of expression, but still with the connection to freedom of religion or belief. We are doing these webinar series together with the Office of the United Nations High Commissioner for Human Rights, as well as with the International Panel of Parliamentarians on the freedom of religion or belief. What is special about this one that we're doing today is that we're connected with the conference on Empower Talk, Standing Against Hate and Embracing Rights, which is taking place in Tirana in Albania. This conference is being organized by the University of Essex under the leadership of one of the panelists of today, Professor Ahmed Shahid, who is the former UN Special Rapporteur on Freedom of Religion or Belief. And that conference in Tirana is being co-sponsored by the United Nations Office on Genocide Prevention, the United Nations Special Rapporteur on Freedom of Religion or Belief, and the UN Office of the High Commissioner for Human Rights. And it's the government of Albania that is hosting that conference. So we're very happy to have you here with us as well. Now, why is the topic of today so relevant for us at the IPU? Well, freedom of expression is an essential tool for members of parliament. Without the right to freedom of expression, parliamentarians would not be able to do their work properly. If they don't have that, how can they effectively represent the interests of those who elected them to office? At the same time, we see that members of parliament themselves face challenges in exercising their freedom of expression. We have a committee on the human rights of parliamentarians, and this committee that receives complaints has a number of complaints with regards to situations in which members of parliament have faced difficulties precisely because they exercise their freedom of expression. At the same time, the IPU is interested in freedom of expression because parliamentarians can do much themselves to help promote and protect freedom of expression for ordinary citizens. And the same is true as well when it comes to freedom of religion or belief. Here too, parliamentarians can find themselves in very different kinds of situations. On the one hand, they can be members of religious communities and belief communities, and it's important that their rights are respected. So that's something that the IPU is interested in, but also at the same time, members of parliament can also misuse their freedom of expression to promote hatred based on religion and belief. And at the same time, parliaments can also really engage effectively and positively on issues of religion or belief. Now, what we would like to do in this particular webinar is to zoom in a little bit more on the tension that exists between, on the one hand, freedom of expression, and on the other hand, freedom of religion or belief. Now, it's clear that freedom of expression, as I said, is very important. It's not an absolute right. There is a certain scope which is defined on the international law. There are certain limitations. But as I said before as well, it's very important that members of parliament in particular are able to express their views freely without fear of reprisals. So it's clear that hate speech as such is not illegal per se. It can be awful, but lawful. So where are the limits here? Where is the threshold in terms of when freedom of expression amounts to incitement to discrimination, hostility, or violence? This is something that we would like to dig into a little bit further in the course of this event. Now, before I introduce the panelists, I would like to make a couple of housekeeping remarks. So, as you have seen from the program, this event will last 90 minutes, and we would really try to stick to that time, knowing as well how busy you are. There will be experts who will intervene, and to be followed by a Q&A. Participants who would like to put questions to the experts. I'm sorry, I just hear someone intervening. The experts, if you would wish to put a question to the experts or want to make a comment as part of the conversation, you can do that through the chat. So if you go on your Zoom screen, you will see the chat. You can put your question in the chat and we can pick it up from the chat. You can also decide to put your question by using the React button. There you can raise your hand and we will keep track of this so we can see that you've expressed a wish to interact. We're not asking you to already sign up now, but wait for the different presentations, and then we will start to take note of that. The webinar is being recorded. It will be available on the IPU YouTube channel and with a link on the IPU homepage. We all kindly ask you to keep your cameras on and your microphones off. This was also just in regards to the person who we were still hearing and who we can still hear now. And maybe the last two comments still on the housekeeping rules. So if there's interpretation in 4 languages, English, French, Spanish, and Arabic, and you will find the button for interpretation on the bottom of your screen where it says interpretation. And in terms of your naming for this event, we would kindly ask you to look at your names, how you appear, and particularly for the members of parliament, if I could ask you to rename yourselves by putting MP first with a comma, your country and your family name. With that being said, I would like to introduce the panel and the speakers and the respondents. So we will have 4 speakers today. We will have Mr. Rafael Vagliano, who is a legal officer at the Center for Law and Democracy. We will have Mr. Ahmed Shahid, Professor of International Human Rights Law in the School of Law and Human Rights Center at the University of Essex, and a former UN Special Rapporteur on freedom of religion or belief. We will have Ms. Carmen Asiain Pereira, who's a member of the Uruguayan Senate and a member of the IPU Committee on Human Rights of Parliamentarians and a network member for the International Panel of Parliamentarians on freedom of religion or belief from Latin America. And we will have Mrs. Nusrat Shaban Hanye, who is a member of the National Assembly of Tanzania and also a network member for IPPFoRB, but from Africa. We will have 2 respondents, Mr. Paul Hunt, professor at the Department of Law at the University of Essex, and a former Human Rights Commissioner from New Zealand, and Ms. Nazila Kanea, a UN Special Rapporteur on freedom of religion or belief. Now, the event is divided into 3 parts. First part will deal really with the legal framework, so the international legal framework. It's Mr. Vagliano from the Center for Law of Democracy, who will explain in a couple of words what the legal framework states when it comes to freedom of expression. Then Professor Shahid will speak more about the intersection between freedom of expression and freedom of opinion, freedom of religion or belief, and in particular the intersection when it comes to hatred based on a religion and or belief, and tell us a little bit more about what the international standards tell us. Then we will have the perspective, the national perspective from 2 members of parliament. So we have Mrs. Asiain from Uruguay, who will share a little bit more about the legal framework that is in place in Uruguay, and also what her perception is of how this is working in practice. And then she will tell us a little bit about the challenges that she sees relate to hatred based on religion or belief in her national context. And Ms. Shaban from Tanzania will do the same for the Tanzanian context. So that's the first part. The second part, we will look more at good practices and challenges. I will say a couple of words when we get to that with Mr. Valiano as well, picking up on, again, the relationship between freedom of expression and freedom of religion or belief. And then we will delve a little bit deeper into some of the other practices and standards that exist. But let's first start with the first part and start with the international framework as it concerns freedom of expression. And for that, I'm gladly giving the floor to Mr. Valiano. You have the floor.
Thank you very much, Rogier, and thank you for this invitation to speak today and for this very important initiative. I have just a few slides, so I'm going to just share my screen. 1 second. Hopefully that should be visible now. So I'm going to give a somewhat of a whirlwind tour of some of the international standards around freedom of expression, which is a very important topic. It's important for parliamentarians to have a basic understanding of these guarantees. So freedom of expression is guaranteed primarily in a few different instruments under international human rights law. One of them is the Universal Declaration of Human Rights, and there is a guarantee found in Article 19 of that instrument. Also, in another Article 19, we find a guarantee in a separate instrument, the International Covenant on Civil and Political Rights, or the ICCPR. This is a widely ratified and binding treaty. And also you find different, but in many ways quite similar guarantees on freedom of expression in a number of regional treaties, for instance, on in the Americas and in the African context, and also in Europe. I'm going to be focusing in this presentation primarily, for the sake of simplicity, on the guarantee in the ICCPR. So freedom of opinion is guaranteed in Article 19, subsection 1 of the ICCPR, which states that everyone shall have the right to hold opinions without interference. This is an absolute right. And the article continues in Article 19, subsection 2, so the next subsection, to outline the guarantee of freedom of expression. And it states that everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through a media, or through other media of his choice. And you may notice that this is quite a broad definition of freedom of expression. It's quite forward-thinking for the time. So you have a definition that applies not only to individual citizens, it applies to everyone. So that includes foreigners, for instance. It includes prisoners. It includes children. There may be restrictions, and we'll talk a little bit about restrictions in a bit for those different kinds of groups that are different. But in terms of the actual right, it applies to everyone. It applies across borders, so not just within a country. It also applies to different kinds of media and the media of his choice. So at the time, they couldn't have thought about all the different technological developments that would happen later on, such as the advances in digital technologies and the internet, but it applies to all these different kinds of communications. It also includes not only the right to impart information, but also the right to seek and receive information and ideas of all kinds. So this is an aspect that's sometimes overlooked, but a very important aspect of this right. So basically, the way international human rights law approaches the matter is that freedom of expression is not an absolute right, and it can be restricted to protect certain compelling interests, such as security, reputation, or privacy interests. But it starts with this very broad worded protection, but it imposes a very strict test on how whether restrictions are legitimate or not. And I think this test is quite an important test for parliamentarians, because it's quite a powerful tool to be able to see whether or not policies and laws and the way they're being applied are consistent with international standards or not. Now, in general, international law does not require states to impose restrictions on freedom of expression, but rather allows states to do so when they meet this three-part test. However, there is one exception, and that is outlined in Article 20 of the ICCPR, and this concerns propaganda for war and hate speech. The way it's worded in there is advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. So for that, states are actually required to restrict, to prohibit this kind of speech. But it's important to note that any such restrictions on freedom of expression on those grounds still have to meet the three-part test. So I've talked about this three-part test. What it is exactly is found in Article 19, subsection 3 of the ICCPR. The first part is that any restriction has to be provided by law. The second part is that it aims to protect one of an exhaustive list of interests which are listed in that article, in paragraphs A or B of that article. And this includes, among other things, the respect of the rights of others, which is most relevant for today's discussion. It also has to be necessary for the protection of that interest. Now, each of these steps has been elaborated on quite a bit by different international bodies because you have quite similar tests under various different international treaties. So I'm not going to be able to get into every aspect of the test, but I'd like to just draw your attention to a couple points quickly. So under the provided by law part, this does not just mean that it has to be a law, but rather it implies a number of things, which include that the restriction has to be sufficiently clear and not vague. And the idea here is to give fair warning and not allow others to determine effectively what the scope of the restriction is. It's also important for the restriction to be accessible, which normally means that it's published so people are able to understand what the restriction is. What the law is, and not to allocate too much discretion. And that's an important thing, because when discretion is too much, there's too much discretion in how you interpret something, that can lead to various problems, and it's no longer going to meet the threshold for being required by law, provided by law. And it should meet the requirements under the domestic legal system for how you enact a piece of legislation. I also just want to draw your attention to a few points on the necessity part of the ground, so the third part of the three-part test. It's important that the restriction, be the least intrusive measure which can effectively address the issue. So if there are different options which would provide for the same result, you should choose the least intrusive option, meaning the one that will least impact freedom of expression and still achieve the same result. It's also important for the restriction not to be overly broad. And also the necessity requirement implies proportionality. So the proportionality test is basically a balancing between the harm to freedom of expression and the compelling interest. And it would include things like also whether sanctions are disproportionate. So if you have, for instance, a law combating hate speech, but it provides for excessive sanctions, that can no longer meet the proportionality part of the test. And if any of the stages of the test, the three-part test, fail, then it's considered illegitimate under international human rights law. So I hope that's a helpful overview of some of these standards. And again, I think this is a powerful tool to be able to evaluate restrictions on freedom of expression and whether they are consistent with international human rights law. Thank you.
Thank you very much, Mr. Valiano. I know how much of a challenge it is to do this in just a couple of minutes. I'm saying this as well because together with your organization, we've done a massive online course for parliamentarians on all the intricacies of the right to freedom of expression, and there's just so much to say. But thank you for this nutshell. I would now like to give the floor to Professor Shahid, who will also in a couple of minutes tell us a little bit more about how freedom of religion or belief relates to freedom of expression, in particular when it comes to hatred based on religion or belief. Professor, you have the floor.
Good afternoon. Can you hear me now? Very good. Thank you very much. First of all, thank you so much for inviting me to join this very important discussion. It's a real honor to be here. And I won't repeat what I said. I would say that my task has been made very easy by the first presentation, which in very succinct manner outlined the limitations regime. I want to start by noting that the right to freedom of original belief, as in the ICPR, has two broad dimensions. One is the internal dimension, the right to believe or not to believe or change one's beliefs. And this right is unlimited. It cannot be interfered with in any fashion. The other is the external dimension, which is the right to manifest one's religion or belief in worship, observance, practice, or teaching. Obviously, this requires communication, expression, therefore is linked to the Article 19 of the ICCPR. The limitations regime applies therefore to this provision and is broadly similar to the one we just heard, except the wording is slightly different. Instead of national security, the provision is for public safety, which more clearly ensures that the concern here is, the referent here is people, public safety, not the abstract notion of national security. So slightly more restrictive, I would say, in that sense. Now, I want to focus more on the very interesting link the three provisions form. Article 20 of the ICPR, along with the freedom of expression and freedom of belief. And I would argue that, of course, on the one hand, you need to protect the right of expression to be able to manifest your original belief. Many countries actually protect the provisions on Article 18 fully in the Constitution or the legal framework, but then comes to restrict that through a backdoor by restricting provisions on Article 19, restricting how you can express your right to expression. And that's one way of saying we protect religion or belief, but then undermining it through restricting expression. So that is the link what we see there. But I would argue that also when properly formulated by in the legal framework, these two rights can really reinforce each other. And in fact, be a very powerful tool when used correctly to combat incitement to hatred, incitement to violence, and discrimination. Now, this may sound like an odd claim because around the world we see people weaponizing either religious beliefs to promote hatred or using free speech arguments to attack people on the basis of their identity. Now, in the first case, we have many examples of people using religious doctrines or beliefs to exclude otherized people, usually dissenters or people who disagree with them. So using their religious beliefs to argue that from our perspective, you are not a human, you're not fully human, or in some other ways, doesn't deserve equal treatment. So using very powerful religious doctrine or religious beliefs, say, look, according to our beliefs, you don't have a right to live, for example. The apostates get this treatment in some cases. But there are other examples of this as well. And there are those, of course, from a different perspective, doesn't use religious argumentation to justify their claims, but might use the free speech argument to say we have a right to free speech, and therefore we will very robustly, of course, criticize you. But then in that process, actually go and dehumanize people. Now, they would, of course, say we are not actually attacking people, we are attacking a belief system. Of course, there is this question of how do we distinguish these two. So for me, the reason why I argue that the intersection of these two rights, expression and religious freedom, can be a powerful tool is because of the limitations regime. Because international law does not give one a license to use one's beliefs to incite imminent violence against people, we can say that the extent is covered in the framework. Likewise, we cannot use the right to free speech to incite imminent violence against other people, regardless of their religious beliefs or doctrines or teachings. That's where I think we come to the notion of the rights limitations provide a space in which people can freely exercise their rights. Now, to argue that from here, that provides us a tool to combat is to go one step forward. Let's recognize that we need the communicative space these rights can give, to use religious resources to challenge intolerant discourses. Now, religions are very rarely, if ever, monolithic. They are almost always very diverse. There are important discourses within each religion. But for that to take place, for that discourse to take place, there must be a protection of freedom of expression. If a state or others didn't allow people to challenge within themselves, their own views, we'll never get to a diverse narrative or different narrative. So the proper use of freedom of expression can provide the communicative space for faith actors among themselves to look at their own resources, to argue from their own religious-based arguments on what is, more tolerant, what is more universally accepted, or what is more, if you like, comply with human rights standards. So, and we see many examples of this. Nearly all, well, every faith I am aware of has one common ingredient: recognition of equal human dignity. Of course, there are many variations thereafter, but if you permit people to engage in healthy debate among themselves, there'll be a variety of views coming along. The plurality of views within a tradition gives opportunity for diverse perspectives, which can then filter out, if you like, more, if you like, tolerant attitudes. But more than that, it also enables people to have access counter speech, challenge hateful discourse within their own communities. Then when it comes to the idea of free speech being used to attack people, again, the idea that you cannot use speech, as we heard, to harm the rights of the people is a limitation here. But going beyond that, using free speech as providing the platform, people to engage, provide space in which we can engage in education, awareness raising, other things are required to build a society in which there's more tolerance and there's more acceptance and there's more respect for everybody's rights and so on. And it's important to remember that when we apply the limitations regime, that we're looking at a very strict, meeting very strict texts as we heard. So if you look at Article 20, if you're talking about a hatred that constitutes incitement to discrimination, hostility, and violence. In other words, it's incitement to violence, incitement to action that we are talking about here, not just speech that is, as I heard at the beginning, awful but lawful, that exists. And how do we get there? We have legal guidance on this. We have the Rabat Plan of Action, the 6-part threshold test, which provides a guideline on how to assess when speech reaches a threshold of states having to prohibit. That states have an obligation to prohibit speech that goes into incitement to imminent violence. Of course, there can be other responses as well, but that is a duty states have, again, coming from the rights framework. And then below the threshold, states can facilitate, and in my view should facilitate, engagement that enables people to challenge other forms of hate. Because human rights are interlinked and interdependent. If one set of rights are undermined, then it affects other sets of rights as well. So states have an obligation to facilitate the use of freedom of expression by everybody to have this exchange. So I would argue that whether one is using religiously grounded arguments to promote intolerant beliefs and to advocate hate against other people, or whether one is using secular arguments to target faith-based communities or their doctrines or their beliefs or whatever else, in ways that are detrimental to their actual people. In both situations, the regime of limitations will enable states to come in and intervene here. Of course, beyond this, states must do a lot more to ensure they have a framework in which people can fully exercise these rights. So my argument that the intersection provides actually a very powerful tool to combat hatred is based on this. They are limited. They can be limited when strict thresholds are met and tests are met. And more than that, they provide essential space for examination of religious beliefs, their own critiques, as well as the space to challenge the discourse that are, if you like, awful and can ultimately lead to violence that is to be prohibited. Thank you.
Thank you very much, Professor Shahid, for helping us in this as we're navigating between these two different rights. I would now like to give the floor to Senator Asiain from Uruguay to give us a Uruguayan perspective on this. And first of all, to tell us in a couple of words what the legal framework is in Uruguay, and also what some of the challenges are in this regard.
Uruguay has subscribed the majority of the international treaties on human rights, so as well as the IPPFoRB. That's part of the Uruguay system. As a regional perspective, we are part of the American Convention on Human Rights that protects similarly the freedom of belief and the freedom of expression. I am going to share my screen so that you can see like the headings of these standards. Can you see that? So both rights are protected in a very similar way as they are protected as well by the IPPFoRB. At the constitutional level, the freedom of expression is protected as well, even on a bigger scope, because there are no restrictions whatsoever in our country. The freedom of expression of feelings is protected with the furthest scope. Also, the freedom of religion. For the parliamentarians, we've got a specific rule that has like a specific scope for the freedom of all type of votes and opinions, so that the parliamentarians, the members of the parliament, can never be prosecuted or can never be, let's say, judged because of their parliamentary opinions. So the freedom of expression that we have in our country, it has a bigger scope than the ones that we are talking here. About our criminal law, the legislation that we have below the Constitution protects the freedom of expression and also the freedom of religion, and punishes any kind of offense, defamation, slander. Also, it punishes the incitement to hatred, to violence with regards to the religion, and also acts of hatred and acts of violation are totally forbidden, because we've got an anti-discrimination law, and we also have the law of press that accounts for the press media responsible or liable for their actions. So they've got all the responsibility according to the legal framework. In practice, what happens? Because this is just the theory. And here we've got some examples. This person was the Ministry of Education and Culture. And the news say that she had the LGBTI aesthetics in the Carnival of Rio. And she was pretending to be looking like the Virgin. So that was very polemic, because we can ask about the limits between one thing and another. It didn't have any consequences anyway. On the previous period in 2018, during the Diversity March, there was also a civil servant from the state that went through the promenade together with these sisters. We also have several damage against assets in different temples. This was during 2020. There was a march on the International Day of the Woman, and it doesn't normally have consequences. It's usually taken as freedom of expression. This last image was during the march of the Women's Day in 2024. I don't know whether you can see that properly, but there is like a head with a David star that has like an arrow through that. It didn't have consequences either. We have also minors participating. It was actually reported by the Jewish, but the court decided that it had to be filed away, so the action didn't go through. Despite of the fact that the Jewish community said that this would incite the hatred actions against a specific group. But this was taken as an expression, as a freedom of expression issue. So what can we see here? At the parliamentarian level, I don't have any news about expressions of hatred or freedom of expression executed against religion communities, because the religious issue is quite absent from the parliament at the general way. We've got a trend, we can see a trend in general to prioritize the freedom of expression over the freedom of religion. So in this way, the balance goes for the freedom of expression, despite of the fact that in the standards, in the legislation, we would have the freedom of belief and religion protected. And therefore, some types of expressions would be like punished because they go beyond some limits. So there is a tension between freedom of religion and freedom of expression. But we believe that one of them is more important than the other. Although both freedom would have to be protected in the same way because they are totally related, and freedom is just one. We shouldn't have two different types of freedom. So there shouldn't be any kind of conflict whatsoever with these kind of rights. So this is the landscape that we have in our country.
Many thanks, Senator, for this very interesting portrayal of the legal but also practical situation in Uruguay. Very interesting to see the examples that you've shown and how how things are weighed both by the courts and by the prosecution in case it comes to that in Uruguay in these kind of situations. I understand that Ms. Shaban from Tanzania is maybe caught up in a parliamentary session right now, that she's not available with us at this point in time. Maybe she's able to join us a little bit later. So the suggestion is to move to the second part of this webinar, which is around good practices and challenges in countering hatred on the basis of religion or belief and upholding freedom of expression and information. I'll say just a couple of words about the IPU. I've already said some things in my introduction. As I mentioned before, both rights are very dear to us, and we have actually done a lot of work on freedom of expression, and in more recent years started to do quite a bit of work on freedom of religion or belief. And for us too, this is a very interesting exercise. It's a real opportunity to sort of see how these different rights intersect. So when it comes to freedom of expression, as I mentioned before, we have a dedicated committee on human rights of parliamentarians, which looks at cases of alleged violations affecting members of parliament who are facing reprisals for using their freedom of expression. So that's an important part of the IPU's work. We've developed, together with the Center for Law and Democracy, Mr. Valiano and his colleagues, and UNESCO, a dedicated course for members of parliament, precisely to help them understand better what international standards on freedom of expression are about, the scope, but also the limitations that come with that, and how parliamentarians can actually navigate in that and use their powers to promote and protect freedom of expression. Obviously, not just for themselves, but for everyone, which gets me to the third aspect, which is where we also try to make a difference in working with parliaments, is to help them with specific legislation where they are making a request to us to help us with legislation that touches on issues related to freedom of expression. And at the same time, as I just mentioned, increasingly the IPU has become involved in matters related to religion and belief. We make full use of the IPU assemblies to offer a platform for these topics to be discussed. Like, for instance, in 2023, the main topic of debate was promoting peaceful coexistence and inclusive societies, fighting intolerance. There was a declaration, it was in Manama, in Bahrain, a declaration that was adopted around that. And the UN Special Rapporteur, Ms. Ganea, was there with us as well. Reports, a bit like with freedom of expression as well, the IPU tries to provide as much information as possible to parliaments to better understand how these issues affect them, but also give them an opportunity to share their perspective. So there was a report on religion or belief that came out in 2023, and later this year, the second part should become available. And then there's the series of parliamentary conferences on interfaith dialogue, where there are multiple stakeholders that have an opportunity to come together and discuss on, in particular, how parliamentary engagement with religion or belief could promote more peaceful and inclusive societies. So a first one took place in Marrakesh, and next year we'll see another one in Rome with the help of the Italian parliamentary authorities. I would like to give the floor back to Mr. Valiano as we start the second part, for you to also say a couple of words about the role of parliamentarians encountering hatred on the basis of religion or belief and upholding freedom of expression information. You have the floor.
Thank you, Roger. I want to say that parliamentarians have a major role to play in combating hate speech generally, and this also includes hatred on the basis of religion and belief in particular, while simultaneously upholding international human rights standards, including on freedom of expression. And this is important not only to uphold freedom of expression, but also because this is in many ways the most effective way to go about combating hate speech. One of the main roles is in the role of parliamentarians as legislators. It's important for them to ensure that the legal framework in place in the country is consistent with international standards, and to work to make any necessary changes. This includes reviewing things like general laws on hate speech and whether they're worded correctly and interpreted correctly. Also reviewing related laws, for instance, if there are general laws on blasphemy that's considered illegitimate under international human rights law. So it's important to review the framework and also look ahead to new challenges. And there have been a lot of important developments recently in terms of how to deal with the proliferation of online harms, and that includes religious-based hatred online, and a lot of interesting developments in that respect in a number of jurisdictions. So it's good to be aware of those things and to think about what's appropriate in your jurisdiction. One of the initiatives has been, for instance, the UNESCO guidelines for the governance of digital platforms, which has been an interesting initiative to try to crystallize some standards in this area about how to go about regulating some of the systemic drivers of some of these online harms. Another important role for parliamentarians is to exercise their oversight role appropriately and to ensure that any laws on hate speech are being implemented appropriately. And this would, of course, involve consultations with impacted parties, including, among others, religious communities subjected to hate speech. And finally, I would just like to point to the importance of parliamentarians setting a good example in their own work. And parliamentarians are, of course, quite high-profile figures. Their words and actions have quite a bit of influence in society. They tend to be quite influential. Appropriately, parliamentarians benefit from a number of protections for their speech because political speech is quite important. But it's important to not abuse these rights. And even if it's technically legally permissible for parliamentarians to say certain things which are discriminatory, that doesn't mean that they necessarily should. And it's important for parliamentarians to hold themselves to a higher standard. And in the context of religious hatred, this would mean avoiding discriminatory remarks and becoming sufficiently knowledgeable about the religious communities and traditions to be able to avoid making comments which offend people's sensibilities. And also means approaching discussions of sensitive topics such as immigration or minority rights in a sensitive manner. And it also means that MPs should use their platforms to call out and condemn hate speech. And in terms of holding themselves to this higher moral standard, then what is necessarily allowed to them under the law. One of the ways that parliamentarians can do this is to consider self-regulation and voluntarily adopting charters. That's something which some political parties have done to bind themselves to, or hold themselves to higher standards when it comes to intolerant speech. Thank you.
Thank you very much, Mr. Valiano, on shedding a bit further light on what parliamentarians themselves can do. And as you say, there's a lot they can do from through the constitutional prerogatives that they have, but also you highlight the special responsibility that they have as social leaders in using their words wisely, because precisely because of the following that they have. The impact of their words can also have can be much bigger than for other citizens in society. I would like to give the floor back to Professor Shahid. I know you already started touching a little bit on the Rabat plan of action and the 6-part threshold test, but over to you to delve a little bit deeper into this, and maybe you can also give us some concrete examples of what we should be thinking of for each of these different elements of the 6-part threshold test.
Thank you very much. I think, in regard to, say, religious actors, the Rabat Action Plan itself, before the 6-part threshold test, asserts the important principle of challenging hate speech through more speech, counter speech. And in regard to religious hatred, I think there's a very important role that religious actors can play in challenging hateful narratives based on religion, because they can speak with authority, authenticity from their respective religious backgrounds. But Rabat Action Plan also provides 6-part threshold test for the state to discharge its obligations in regard to assess what speech requires what kind of response. So the 6-part threshold focuses on things like the speaker. The speaker is important because some speakers have more influence of immediate action than other speakers. So the speaker can be very important element in assessing whether the speech is likely to cause harm. Then, of course, the context matters. Context actually is king in most of these conversations, because when the speech is spoken in a situation of high anxiety, for example, then it's more likely to cause more damage than one which is done in different context. Say a classroom where I teach, in a classroom context, very unlikely speaking about things that people might find difficult in the public space would cause the same reaction. So the context actually matters when the speech is made. The content and form also matters because what is said precisely is important to assess whether or not what reaction the state should actually be looking at the particular situation. The extent of the speech, was it a one-off comment? Was it something someone keeps repeating deliberately? Of course, over time and time and again, because then the dissemination of that becomes more widespread. And through that, of course, the potential for instigation of violence based on that is quite significant. And of course, intent matters, but matters mostly at the highest threshold because of the criminalization that may be called for in very exceptional situations. But intent of the speaker matters. Again, if you look at other contexts, like I teach regularly, and there are many instances in which I would take up topics that are quite taboo. And my purpose here, of course, is to educate in a very respectful, controlled situation. And I couldn't do the same thing in a different space. So if it is educational, then obviously intent is clear. Or if I'm using the same material to incite hatred towards some community, that can be also easily understood, therefore is a concern. And then finally, and perhaps the most important element here, is the likelihood to cause imminent harm, imminent violence. That is very important. Of course, different jurisdictions define this differently, but the element here is that what is really requiring the most urgent response is that is likely to cause the most imminent violence towards somebody, because there's no space to intervene with counter narratives, solidarity, and challenging of that speech. But wherever there is the possibility of challenging that narrative, showing solidarity, and therefore sort of toning down the impact of the speech, that's to be favored here. But I also want to touch upon the role of religious leaders. Of course, who have an important role in the counter narrative space, because they can be very powerful tools in delegitimating hateful narratives that come as religious doctrine. That is one. But if you look at the FEZ action plan on the role of religious actors on combating incitement to violence that can lead to mass atrocities, a whole range, I think over hundreds of actions in that, not just for religious actors, but also for whole society, media actors, state, and so on and so forth, including parliamentarians, that go from actually creating a better understanding amongst people, and then, of course, challenging hateful narratives. And of course, a key initiative that really stands head and shoulders above this, I suppose, is the Faith for Rights Initiative at the OHCHR. It's very much focused on ensuring that religious leaders have a positive role to play in ensuring that they tone down hateful narratives and create actually inclusion, sort of cohesion, contribute to going beyond this counter speech to creating the framework in which there's more awareness about each other, there's more acceptance, and there's a united platform, as it were, of using their moral authority. Again, this is based on people of all faiths and none, so everyone's authority, moral authority, to challenge it. And this really is a very, very, very positive example. But I also want to highlight that beyond using religious resources, and of course, the legal framework for parliament is important, but I also want to talk about political will. And that's something I think parliamentarians are very well placed to generate. Very often in this space, what is lacking is a political will to act on something. And I think around the world, there are again many good practice examples here. And in many contexts, there are countries allocating resources through parliamentary intervention to create a monitor on hate speech, to create a national action plan and provide resources to make it work. Or they may have parliamentary committees, human rights committees, or other committees that call for regular hearings or other ways of reaching out. So making people feel heard, cared for, understood, and of course, parliamentarians caring for it. That's a basis for creating political will. In fact, shows will, but it can create more will as well. I think around the world, there's a lot of that. So ultimately, if we set back from the legal work that parliamentarians do down to the more sustainable long-term solutions, looking at building up social cohesion. Even for that, there's a legal requirement. Inclusion can be undermined by legal frameworks and gaps that create hierarchies of people, but legal framework is one. But more than that, there should be the inclusive people in education and social services, both the objective understanding of it, but subjective sense of we all belong here. This is something I think parliamentarians can create through their influence in society, their educational role, their epistemic role. All of that can come together to really contribute to both the legal framework and the sort of cohesion that can sustain these counter narratives that can make advocates of hatred, the awful speech, less harmful. Thank you.
Thank you very much, Professor Shahid, for this, for the explanation of the Rabat Plan of Action and the 6-part threshold test, including with examples, and also the additional work that you pointed to that has been done since, which is also very valuable in providing further explanations in this area. I also really hear you when you emphasize both the legal together with the social dimensions of dealing with this, because and we see this as well in working with parliamentarians on freedom of expression issues. It's on the one extreme, one would argue there is not the right not to be insulted doesn't exist, but there's also no obligation to insult. And so we sort of navigate between these two extremes. And there's also, just by applying a lot of common sense, you can get very far. And of course, common sense is on the assumption that this common sense is shared by everyone in the room. But thank you so much. I would like to turn back to Senator Asiain for this time more of a personal perspective and a perspective on your role and what you see you've been able to do when it comes to these two rights in Uruguay.
In the conceptual note that we have received, we were talking that we use different hats. And that applies to my case, for example, because I'm a solicitor, I'm a teacher for the constitutional law and human rights as well. And I got a specialty as well related to the freedom of religion and freedom of expression. So because I've been in the academy and I have a role in the parliament, what I do first is to suggest or propose a series of projects to try and modify or improve situations that I could see that were unfair in my country. The issue of the freedom of expression was protected by the freedom of religion, because there were many people who were they were using they were a fundamentalist secularism, which was part of Uruguay. So religion was kind of forgotten. So then I submitted a project to regulate the freedom of conscience and ideas and constitutional ideas, and that's not considered. It doesn't comply with all the different requirements of support, and I know then I become part of the government, and then we are the only country in the world that is still sanctioning the Minister for Cults that is celebrating civil marriage without having a religious marriage first. The only one which is valid is the civil one. And then after that, you can have a religious marriage. But there's a law, there is some standard, there's a law that states that if the cult minister is holding a religious marriage without having the civil one first, they could be taken to prison. So my project was to make this sanction disappear, this penalty. It shouldn't be a crime anymore. No, we just wanted that to disappear. Well, that didn't succeed either. And that shows, reflects the ideology, the underlying ideology that says or makes you think that a law cannot deal with religious issues, because that would mean going back to an official religion for the state, and that's not the case here. But there was something that could have been approved in the Senate, was the festivities for the religious minorities. So festivities that could be set off by working days in the education environment or in the labor world. And I would like to share my screen again, because the project was approved in the Senate only with the votes from the different parties, and it wasn't approved in the chamber of or in the parliament. So another thing is going to be approved or accepted. It acknowledged the right to be able to, for example, if you wanted to celebrate St. Yom Kippur or any of the festivities, religious festivities, then you could have a day off. Or, for example, the festivities for the Muslim communities, that could be replaced by another day. And so that wouldn't have a negative effect or impact for the employees. And today we had some news in the press. I would like to share that with you, which is related to it. Yes, I'm looking for it. Bear with me, please. Well, I don't know when I left it. It was a PowerPoint with that. Anyway, this piece of news was that there is a student from the state university that took something to the university to court because he didn't want to go for an exam on Saturday because of his religion, because he was defending the seventh day as a day off. If that project had been accepted or passed, we wouldn't have that problem. There were some conflicts as well because of a minority community, because they were sending their children to some workshops that could be considered at like homeschooling. And that was also reported because they were not complying with the education system, compulsory education system in our country. Here, I just found this this piece of news that I'm going to share that with you. That was dated today, 16th of January. So to sum up, I think it's necessary to provide some kind of training for the parliamentarians as for the freedom of religion, freedom of expression. I think there is an awareness already, and both rights should be assessed and valued. But there is a lack with regards to the training to know what is because that's a fundamental human right. It's not considered as a fundamental human right as a consequence of wrong understanding or interpreting or the situation of the religion in our country. So I think that we had to take all the rights as the human rights statement from Lima as the anniversary of the human rights universal statement, human dignity for everyone, everywhere. And it has to do with providing a value to all the rights and to try to reconcile all the rights together so that all the people, all the persons have the right to use their rights, and you cannot give priority to some of the rights and then not knowing about the existence of other rights. That was part of some of the conclusions for this Latin American Consortium for Freedom of Religion or Belief in 2015. So that there should be a harmonization, a reconciliation, and also it also calls for the responsibility from the governments when they are adopting certain agendas. Responsibility to provide the situations that the minorities are also attended and cared for with the rights. And that's my personal perspective. Thank you.
Thank you very much, Senator, for sharing this on what is happening in Uruguay, and also how you've personally been involved in this. It's very interesting to hear. I'm mindful of the time. We still have 25 minutes, and we're now turning to the question and answer section of this event. As I mentioned before, for those who want to put a question, you have two possibilities. Either you can put your question in the chat, and we will look at what is in the chat regularly. You can also use the button at the bottom of your screen, which says react, and there you have the possibility to click on raise your hand. So if you want to speak and use that as an opportunity to ask your question, that's also possible. So I would encourage those who want to do that now, because as I open the floor for the Q&A, I first of all would like to give the floor to Mr. Paul Hunt, who's a professor at the Department of Law at the University of Essex and a former Human Rights Commissioner of New Zealand. And many other things as well, because I know he has a very long CV. But I would like to ask him to give us his insights into countering hate speech and upholding freedom of expression as it relates to religion, belief, or culture, and with a particular reference to your experience of when you were a Human Rights Commissioner in New Zealand on this.
Very many thanks to IPU and the Office of the High Commissioner for Human Rights for organizing this webinar, and thank you so much for inviting me to make a few personal remarks about issues I've observed in practice for some time. I'm not going to respond with a lot of law. Others have expertly done that this afternoon. Instead, I make a few short reflections which are less about law, but as I review them, they're more about process. First, to be absolutely clear, democracy is not just about free and fair elections. Although free and fair elections are extremely important, democracy has other crucial components, such as an honest public service, an independent judiciary, fair media, and also human rights. So parliamentarians have this really heavy responsibility to listen to their people and to uphold human rights. And parliamentarians, as we know, they have this constitutional role of lawmaking, including laws in relation to hate speech. Hate speech, of course, causing real harm. When approaching hate speech legislation, I respectfully suggest it's extremely important to listen to communities, consult with communities, not just consultation with the powerful, those who are influential, with people with privileges and advantages, but it's imperative to reach out to disadvantaged people who are often the targets of hate speech. As we know, reaching these disadvantaged communities is not easy. They may be suspicious of authority, they may be detached from Parliament. So parliamentarians need to actively reach out to disadvantaged people and be willing to listen to them. Whether parliamentarians are approaching law reform or not, I suggest that parliamentarians have a crucial role to play, what I call a crucial role to play in what I call difficult conversations. And by difficult conversations, I mean conversations that are polarizing, divisive, and controversial. And difficult conversations can easily escalate into hate-filled conversations. And parliamentarians have a vital role to enable difficult conversations to take place without hate. These difficult conversations are really hard, and they need great care. Basic rules have to be agreed beforehand. A good moderator is vital, possibly a parliamentarian. The meeting for the difficult conversations might be a closed meeting with agreed participants and not always open to the public. Those having the conversations must be willing to agree to disagree. The aim is to listen and learn, not necessarily to agree. And difficult conversations are difficult because we might have to sit with people who, frankly, we don't care for very much and we don't like their opinions, but that's not the point. But it seems to me that parliamentarians can model these difficult conversations. They can show the way. Democracy and human rights require parliamentarians, and indeed it requires all of us, to listen to the excluded. And an idea, very briefly, that's closely related to difficult conversations is the value of establishing constructive spaces, or possibly enabling spaces. And it's a great service to establish constructive spaces where difficult conversations can take place. I just said that parliamentarians can show the way. And this, I think, is one of the most crucial roles for parliamentarians in this context in relation to hate speech. Parliamentarians are national leaders. Your difficult role is to demonstrate democracy and human rights. The role is to stand up and speak up for democracy and human rights. So you model democratic leadership for peace and tolerance. You model ethical leadership. I respectfully make an additional short observation. We are not born full of hate. Something has happened to make people feel hate. I respectfully suggest parliamentarians can help us identify and address the root causes of hate. Sometimes these are structures in society which lead to frustration, anger, a sense of grievance, and powerlessness. Of course, we need a legal response to hate speech, but we need to dig deeper and identify what has contributed to feelings of hate. For example, there is evidence that gross inequalities in society may generate deep grievance, anger, and hate. So to conclude, parliamentarians do us an enormous service if they can advance our shared human identity, if they can address structural obstacles, and if they can model democratic leadership, model peace and tolerance, model ethical leadership, and advance social cohesion. Thank you very much.
Thank you very much, Mr. Hunt, for these words and for this appeal to members of Parliament to to use the responsibility that they have wisely and constructively to have these difficult conversations, as you say, that need to be had, where people can agree to disagree, but where everyone finds a place at the table to speak and to be heard, and in particular, as you say, the disadvantaged groups that are so often left out of this discussion to begin with. We have 15 minutes, and I also, before we conclude and we wrap up, I want to give the floor to Ms. Nazila Ghanea, the UN Special Rapporteur on Freedom of Religion or Belief, just to respond to everything that has been said, including the interventions that we will still listen to now. I see maybe a final hand, Ms. Fernanda San Martin. Would you like to come in?
Yes, hi, thank you. Can you hear me? Yes, hi. Thank you so much. Concerning the capacity building for parliamentarians, in fact, we at IPPFoRB, the International Panel of Parliamentarians, that's exactly what we do. We provide support and high-level training for parliamentarians in this specific topic of freedom of religion or belief, with intersection with other human rights as well, but focus primarily on freedom of religion or belief. So we work with parliaments all around the world. More than 95 different countries are represented into our network. We are an informal network of former and sitting parliamentarians. So I will leave, or maybe you can, Roger, leave in the chat our contact and our website. So if you are interested that your parliament or specifically you as an individual in your own capacities as legislator wants to dig more into FoRB and our workshops and our trainings, will be more than welcome to help you out with that. Thank you so much.
Thank you very much for pointing that out, that possibility, and for putting it in the chat. I would like to give the last opportunity before giving the floor back to any final comments from the panelists to the Special Rapporteur, Ms. Nazila Ghanea, for any concluding remarks you would like to make in light of what you've heard today.
Thank you very much. That seems a tall order. I can't summarize the richness of the last 92 minutes, but let me just say, make 3 points that were inspired not only by this seminar, but also the last day of the conference that we have had here. The first is that we've had such a rich range of presentations from different actors. And the first point that I want to share with you from it is that protection from hate speech goes far beyond legislation and the Constitution. Time and again, the presenters at this conference with rich data and experiences shared, in fact, the importance of things being tangible at the community level, at the level of the person or persons or communities that suffer harm because of hate speech, that live in fear, that are disturbed, maybe even their livelihood and their security is at risk. And the local level becomes incredibly crucial because it's the site of the experience, but also the healing. So we need to, if we are not at that micro level and we're at the macro level, whether at the parliament or intergovernmental institutions, we need to be mindful of the real stories, the real experiences on the ground. Otherwise, we are using it for political mileage, for our own electoral process, for popularity. We may unintentionally or maybe quite intentionally be playing the narrative in a particular way that is disconnected from that. So that connect becomes crucial at the national level, regional level, the international level. The lens of the sites where hate speech is experienced focuses also on victim support, on cultural change, and on healing. And so if we are really after social cohesion, then we would be mindful of that. Secondly, we shouldn't only care where we have reached the threshold of criminalization and incitement. We should care at every level, every hurt, every prejudice, every disdain, every sense of disbelonging should be relevant to us. For sure it is for parliamentarians. And we should make sure that for other actors as well, that what we care about is any disturbance, any fracture in society. And at a certain point, then that may lead the correct response, the tailored, appropriate response may be criminalization, but we should care long before it comes to the threshold of incitement and criminalization. So we sometimes, run to the conclusion that if we care, we criminalize. And I think that actually that's wrong, because if you criminalize early, you actually demonize that minority or that victim even more. So you can actually jeopardize them. Then the third point is contextualization. Of the 6-part threshold test that is a guidance for when we might be needing to criminalize, the majority of them relate to the context. So the social and political context, a speech, a term, a slogan in one part of the world may be innocuous and really disturbing in another part of the world. In February, it might be innocuous and safe, and in June, it can be really problematic. So secondly, the status of the speaker. Just watching it on Al Jazeera, on BBC, on TRT will not tell us the status of the speaker. It is those people in that context that understand how influential that speaker is, and therefore what damage can be done from their speech act. Thirdly, even the intent needs to be understood very carefully in relation to where the incidence of hate has happened, and the content and form. In Russia, it's problematic. In neighboring Afghanistan, it's normalized. In UK, it's dangerous. I mean, all of those, the context informs us. So we sometimes see something in the news, and we are convinced that we understand that there has been incitement. So we assume that we understand exactly the dangers involved, their audience, how dangerous it will be, what will be the imminence. And at other times, we fail to look at the actual context. And that's where the deep understanding occurs. So I want to reflect from the last day and a half of this conference, to focus on the community level, to know that we can care far beyond criminalization, and we should be thinking much. There's early warning in every incidence of hatred, and we have many warnings that we need to be mindful of, and parliamentarians are connected with and have a role in all of those. And when it comes to criminalization, we should focus on the context, because that will actually help us understand the imminence, the risk, the audience, and what that hate speech act actually means. So let me just conclude there, and thank you for this opportunity.
Thank you so much, Ms. Ganeo, for that. And I'm just thinking out loud here. I mean, it's you have the legal, you have the social, you have the human, and you have the contextualization. I think it really nicely brings it all together. I'm turning to the panelists to see if they want to make any final remarks or not. I'm looking at Mr. Valiano, Senator Asiain, of course, Professor, and the professor I can't see from here, but I don't know if you would like to make any final remarks, or if you wish to conclude. Senator, you wish to take the floor?
Una reflexión.
Just a reflection.
Tengo, pero estoy, sorry. Comparto nuevamente
I
la
share
pantalla
again my screen with you
para hacer esta reflexión sobre lo que nosotros
to
podemos
have this
llegar a
reflection on
hacer
what the
como
things that we can do
parlamentarios
as parliamentarians
cuando el resto
when the rest
sistema legal y político
The legal
no,
and political
no responde.
parties are not responding, not answering. When the incident from last year, March the 2024, with the face that it was had a spread with the Jewish star, and nothing happened in the courts, in the judiciary department. Then the Senate had issued a statement criticizing it, condemning it. So there is a role of the society and there's a way perhaps to respond, to react when the judiciary system is not doing it. So that was a way to condemn it. That's it.
Thank you, Senator. Anything from Mr. Valiano?
And nothing further, because I think the conversation has been quite rich, and I don't think I can cover everything that's been covered so well. But I would just like to thank everybody for their attention to this important topic, and for all the work that you do, both on a legal level in terms of ensuring that the laws are appropriate, but also just in your daily lives and the way you approach this topic. And it's great that there's so much interest in this topic, since it's such an important issue that that needs to continue to be addressed. So thank you very much, and thank you for this great initiative to organize this.
Thank you, Mr. Valiano. With that, I would like to thank all the participants for being with us today. It's the second one in a series. I would like to thank, on behalf of the organizers, the panelists as well, for sharing your rich experiences and expertise with us. And I would like to thank the interpreters as well for being so patient with us in the course of this event. A last remark, as I said, this is part of a series, so this is the second one out of 4. The next one will take place hopefully very soon, and it will deal with something that wasn't really touched on today, I felt. It's more the digital space and the social media platforms, and how they are also catalysts for spreading hate speech, and what are the ways to counter it. So when we meet next, and hopefully you will be part again of that conversation, you'll be part of that conversation as we address that together. So with that, thank you very much and have a good rest of the day.